Good afternoon, everyone, and welcome to OG Energy Education Series Appalachia Title Update. I am Josh Abrams, and I'll be presenting today. I'm based out of Columbus, Ohio, and I'm licensed in Ohio, Pennsylvania, and West Virginia. So for a little bit of an overview today, we're going to briefly cover West Virginia's Cotenancy Statute. Then we'll look at West Virginia's new Unitization law. We'll take a look at a few updates on the Ohio Marketable Title Act, and then we'll look at the Ohio Dormant Mineral Act. We'll take a look at some analysts of production and paying quantities under an oil and gas lease in Ohio, and then we'll finish up with some Pennsylvania case updates. So for West Virginia's co-tenancy statute, which is basically a precursor to unitization, it's also known as the unitization law is called Senate Bill 694, but before we go over that, it's really important to look at the co-tenancy statute. So prior to the co-tenancy statute, West Virginia was in the minority of states adhering to the rule that development of oil and gas by less than 100% of the co-tenants constituted waste and was actionable as trespass. So under the prior law, operators had to obtain leases from all interest holders of a mineral parcel, regardless of the undivided interest or the number of owners. When there were co-tenants that refused to lease or were unable to be located, operators were left with only a few costly options, including proceeding with development in the form of a partition action or filing an action under the missing, abandoned, or unknown owner statute in order to secure the unleased interest. However, with the passage of the co-tenancy statute, which went into effect on July 1st, 2018, operators are now protected from liability for trespass and waste claims brought by non-consenting co-tenants or owners who cannot be located. So the statute permits operators to develop and produce oil and gas from mineral parcels where they do not have 100% of the oil and gas owners under lease. In order for an operator to actually use the statute, there's basically three elements that must be satisfied. First, the oil or natural gas mineral property must have 7 or more royalty owners. A royalty owner does not include a person whose interest is limited to, only a working interest in a wellbore, overriding royalties, non-participating royalty interests, non-executive mineral interest, or net profit interest. Second, operators must make reasonable efforts to negotiate with all the royalty owners in the oil or gas mineral property. And then 75% of the royalty owners must consent to the lawful use or development of the oil or natural gas. So if the above criteria are met, then basically the operator's use or development of the oil or natural gas property is permissible, is not waste, and is not constituted as trespass. So with the use of the act, the operator must give the non-consenting co-tenants an opportunity to make an election of either a production royalty or a revenue share. The operator must also make a reservation for the benefit of any unknown or unlocatable interest owner, which will then be reported and remitted to the state treasurer. Non-consenting co-tenants must decide between basically one of two elections. First, they would have an election to receive a pro rata share of production royalty paid on gross proceeds received from an unaffiliated third party and also free of post-production expenses equal to the highest royalty paid to the consenting co-tenants in the same property, as well as also receiving any lease bonus, delay rental, or other non-royalty payments calculated on a weighted average net mineral acre basis. Additionally, any non-consenting co-tenant and any unknown or unlocatable interest owner who has elected or has been deemed to have elected a production royalty is subject to and shall have the benefit of the terms and provisions defined by the lease executed by a consenting co-tenant, which contains the most favorable terms and provisions. So you're going to get the most favorable terms and provisions there. Alternatively, the second option would be to participate in the development and receive your pro rata share of the revenue and cost equal to your share of production, exclusive of any royalty or over royalty interest reserved in any lease, assignments, or agreements, but only after the market value of such non-consenting co-tenant share of production equals double the share of such non-consenting co-tenant share of cost. So the election by non-consenting co-tenants is basically triggered by the operator when it delivers in writing its best and final lease offer. So the non-consenting co-tenant would basically just have 45 days following delivery to respond in writing and make their election. Should a non-consenting co-tenant fail to provide a written election before the expiration of the 45 period, then the non-consenting co-tenant shall be deemed to have elected a production royalty. For unknown or unlocatable interest owners, they will receive a pro rata share of production royalty, and then the operator must actually remit the amount reserved to the state treasurer for 7 years. After the 7 years from the date of the first report to the treasurer, a surface owner can then seek to quiet title and obtain a deed for the mineral interest of the unknown or unlocatable interest owners. The surface owner will actually not get the proceeds paid to the treasurer up to that date, but they will get the share of the future proceeds moving forward. I also want to note that operators shall only develop the specifically targeted stratigraphic formation and 100 feet above and below said formation. So non-consenting co-tenants and unknown interest owners will retain all rights to all other formations unless or until reasonable efforts are made to renegotiate under this section for each additional formation. Finally, the statute creates a limited right to appeal for non-consenting co-tenants. 30 days after a non-consenting co-tenant's election, as to the operator's best and final offer, they may file a limited appeal to the Oil and Gas Conservation Commission. However, only 2 issues may be appealed. The first would be whether the operator has given the highest royalty paid in the same mineral property, and 2, to verify value for the lease bonus and delay rental payments. Consequently, operations are permitted to continue during the pendency of any such appeal to the commission. Okay, now moving on to the actual unitization statute in West Virginia. So Senate Bill 694 was passed by the West Virginia legislature on March 9th, 2022, and it went into effect on June 7th, 2022. So the bill is a huge step forward for the oil and gas industry in West Virginia. With the bill, operators can now create drilling units without having 100% consent from the mineral interest owners across all depths and formations for horizontal wells. There are various criteria an operator must meet to file a unitization application. If these criteria are met, the commission shall authorize unitization of tracts. Overall, an operator must meet 3 conditions related to 1 being a benchmark of royalty interest, 2, a benchmark of operator interest, and 3, negotiations with all mineral owners within the proposed unit. So the operator must comply with all of the application requirements as well. So for purposes of this presentation, I just want to focus on the criteria that must be met as well as the application requirements. In reality, there could be a whole separate presentation addressing unitization in West Virginia. So first, as to royalty interest, a producer may obtain a unit order upon getting consent from the mineral interest owners of 75% or more of the net acreage in the target formation to be included in the horizontal well unit. So the mineral interest owners include traditional royalty owners, executive interest owners, and unknown and unlocatable interest owners. So under this formula, a producer may utilize the unknown heirs or co-tenancy statutes, which we just discussed, to add to the acreage to get to that 75% participation threshold. Second, as for operator interest, for shallow wells, the right, consent, or agreement to pool or unitize as to 55% or more of the net acreage in the target formation. And then for deep horizontal wells, the right, consent, or agreement, again, to develop the acreage from executory interest royalty owners of 55% or more. So overall, a producer must control by either ownership, lease, or otherwise at least 55% of the net acreage in the target formation proposed to be included in the horizontal well unit, which threshold applies to both shallow and deep horizontal wells. Finally, the statute requires that a producer make good faith offers to consent or agree to pool or unitize to mineral owners and negotiate in good faith with all known and locatable royalty owners having executory interest in the oil and gas within the proposed unit. So even those whose interests are not subject to development under the co-tenancy statute. Notably, for purposes of determining if these conditions have been met, the commission cannot consider overriding royalty interest owners, non-executive royalty owners, or acreage owned or held by unleased, unknown, or unlocatable interest owners whose acreage is not subject to the co-tenancy statute. Okay, so there are really numerous application requirements here. I included the application requirements in these slides since everyone will be receiving a copy of the presentation today. However, for the purposes of time, I'm not going to go through all the requirements, but just rather note a few. So an applicant must include the following in their unitization application: a description of the horizontal well unit and identification of the target formation or formations, a statement of the nature of the operations contemplated, a plat that depicts the boundaries and acreage of the proposed horizontal well unit, the tracts in the horizontal well unit, the surface tax map and parcel numbers of the surface tracts, as well as the districts and counties or counties where the proposed horizontal well unit is located. Also a list of all oil and gas tracts or portion thereof within the unit, the size of each tract and the extent to which each tract is leased. So somewhat common and similar to other states where we have unitization statutes as well. Okay, next there must be the names and last known addresses of the royalty owners of the target formation of each tract within the proposed horizontal well unit, basically specifying which, if any of them, are known or unlocatable, which of them hold executive rights with respect to owners of an executory interest, whether they have consented to pooling or unitization of the acreage proposed to be included in the horizontal well unit, the names and last known addresses of operators of proposed horizontal well unit target formation acreage, whose interest is of record in the county where the property is located, specifying which of them are known and unlocatable, and which of them, if any of them, are bonded operators. And if it is a bonded operator, whether they have consented to pooling or unitization as to the acreage in the proposed unit. Next, there must be information regarding the applicant's actions to identify and locate the unknown interest owners of the target formation acreage included in the well unit, the percentage of the net acreage in the proposed unit owned by executory interest target formation royalty owners who have consented to pooling or unitization, the percentage of the net acreage in the proposed horizontal well unit held by bonded operators, and the applicant as to which consent or agreement to pool unitize has been granted, and a percentage allocation to the separately owned tracts or portions thereof in the proposed horizontal well unit of the oil and gas that would be produced from the unit as they're determined by the proportion that each tract's net acreage within the unit bears to the total net acreage in the unit itself. Finally, there must be a certification that the applicant meets the requirements of subsection C with respect to the unit, a list of the instruments granting the control, and a certification that the applicant has mailed a copy of the application to all known and locatable interested parties by certified mail to their last known address, a statement whether the applicant has been submitted either previously or contemporaneously with the application, an application for a well work permit with the Department of Environmental Protection for the one or more horizontal wells to be completed within the unit, and then a proposed joint operating agreement that will govern the contractual relationship between the applicant and any unleased royalty owners following an election by the executive interest owners to participate in the drilling of the well unit on a carried basis. So there you can see there's a long list of criteria that must be met for the application. But before moving on, I do want to note that once an order is granted, the order must address how non-consenting mineral owners must be compensated by the operator. So for example, an order must require that non-consenting mineral owners with valid leases whose minerals are included within the unit must be paid an amount equal to one, being 25% of the weighted average monetary bonus on a net mineral acre basis of the bonuses, and two, 80% of the weighted average production royalty percentage paid to other executive interest owners of leased tracts within the unit. Alternatively, non-consenting mineral owners without a valid lease must be given the choice to either one, surrender their oil and gas lease within the, surrender their oil and gas within the tract in the unit in exchange for an amount equal to a weighted average amount paid per net mineral acre by the applicant to executive interest owners in the same target formation, or two, elect to participate in the unitization. Now, if the non-consenting mineral owner consents to participation in the unit, the amounts paid must be either on agreed terms or for a bonus payment equal to the average bonus paid to the other mineral owners by the applicant within the unit, and a production royalty equal to the highest royalty in any lease to a mineral owner within the unit in the previous 24 months. And so that's a quick little rundown there of the unitization statute. As you can tell, it's very, very new. There was recently an action filed to actually against the governor of West Virginia, which was rejected. So I'm sure there'll be more of those actions to come in the future. So it's something definitely to keep an eye out for as we move forward. But now moving on to the next area of the presentation, we're going to talk a little bit about the MTA in Ohio. So the MTA, it's a very detailed statute, and so before we move into some of the more recent cases, I just want to touch on a few items concerning the background of the statute as well as the key sections of it. So the MTA became effective on September 29th, 1961. And so its purpose is basically to simplify and facilitate land title transactions by allowing a title examiner to limit their search of the record for title defects to only 40 years back in time. Yeah, if a person has a record chain of title for 40 years, then any conflicting claims based upon any title transactions prior to that 40-year period are extinguished. So in 1961, the MTA did not bar or extinguish any right, title, estate, or interest into any minerals. This means that the MTA basically could not be used to extinguish disused several mineral interest. This was in line with common law rule where severed mineral interests are not subject to abandonment or termination for failure to produce oil and gas or to extract other minerals. However, in 1973, the Ohio legislature basically amended the mineral interest exceptions so that only coal was accepted from the operation of the MTA. As several Ohio courts noted, it logically follows that if the legislator intended to treat severed oil and gas interests in the same manner as coal interest, then it would have done so in the statute. So by not specifically including oil and gas, the Ohio legislature decided as a matter of public policy that such interests are not within the new exception and that the Marketable Title Act does apply to extinguish severed oil and gas interests. So the amendment in 1973 basically enabled surface owners to clear their titles of unused severed mineral interest as we've seen moving forward here in time. So the MTA is codified in section 531.47, but 531.48 discusses basically, any person who has an unbroken chain of title of record to any interest in land for 40 years or more has a marketable record title subject to certain limitations set out into section 531.49. So if the chain of title is unbroken, if the official public records disclose a conveyance or other title transaction of record not less than 40 years prior to the time marketability is being determined, so long as the conveyance or other title transaction purports to create an interest in either the person claiming the interest or some other person through whom the person claiming the interest can claim title, provided that nothing appears in the records divesting the claimant of the interest. So essentially, there cannot be a subsequent title transaction or other instrument purporting to divest the claimant of their interest. This conveyance or title transaction referenced in the first point is known as the root of title. So if under Ohio Revised Code 531.48, we were able to determine that a surface owner has an unbroken chain of title of record to a tract of land for 40 years or more, such that the surface owner has a marketable record title, then there are still exceptions that could prevent the extinguishment of the severed oil and gas interest. And so really, the main one here is Part A, where it says all interests and defects which are inherent in the monuments of the chain of record title. However, a general reference in such monuments to easements, use restrictions, or other interests created prior to the roof title shall not preserve them unless specific identification is made therein of a recorded title transaction which creates such easement, use restriction, or other interest. And so this is the particular portion of 53149 that was under review in the Blackstone v. Moore case from the Ohio Supreme Court, where the court basically articulated a three-part inquiry for determining whether a prior interest is specifically referenced in monuments for the chain of record title. So not all, but it certainly seems like the majority of MTA cases in the 7th District Court of Appeals, as well as the Ohio Supreme Court, at least in part concern this section. As a result, it's critical to have a thorough understanding of this provision. Another key provision would be Section D, which pertains to any interest arising out of a title transaction recorded after the effective date of the root of title, provided that such recording shall not revive or give validity to any interest extinguished prior to the time of recording. So the title transaction basically cannot be recorded after 40 years from the effective date of the root of title, because the title transaction cannot revive the interest, and the interest would be extinguished after 40 years. So if there is no other exception to a marketable record title, title applicable here. So like I said, A and D are basically the key provisions of 531.49A that you're going to see in most of these cases concerning the MTA. And then finally, under Ohio Revised Code 531.50, subject to the limitations of 531.49 we just discussed, if an owner has marketable record title, then that title shall be taken by any person dealing with the land, free and clear of all interests and claims that depend upon any act, transition, event, or omission prior to the effective date of the root of title. So all such interests and claims prior to the root of title are null and void. This essentially means that if a surface owner has record marketable title to a tract of land and none of the exceptions under 531.49 apply, then any subsequent purchaser of the land takes the land free and clear of the interests and claims that depend on something prior to the root of title for its existence. Okay, so the first case dealing with the MTA is Lucas v. Whyte, which is out of the 7th District Court of Appeals. So in 1914, the Millers conveyed 25 acres in Monroe County, but it reserves 1/2 of the oil, gas, and coal. So Mr. Miller died intestate in 1940, and Belmont County handled the probate of his estate. The Belmont County Probate Court sent a certificate of transfer to the Monroe County Recorder's Office, reflecting that all his real estate, including the severed interest, transferred to his heirs, and this all occurred prior to the root of title. The appellants in this case are actually the heirs to the heirs listed in the 1940 certificate of transfer, and they claim ownership of the severed interest. The surface owner here ended up filing a quiet title action in 2018, claiming that the severed interest was both extinguished under the MTA and abandoned under the DMA. Since the court was able to resolve the case based on the MTA, I'm not going to include any discussion here of the DMA. So for the MTA claim, the heirs argued that the MTA did not extinguish the severed interest because it was subject to various title transactions, and the surface owner did not have a valid root of title. The trial court held that the reference to the severed interest in the root of title was general and did not contain any specific identification of a recorded title transaction. As a result, the severed interest was extinguished under the MTA. So the heirs actually appealed the claim and said that the trial court erred in determining that the severed interest was extinguished by the MTA. And so they argued that the DMA and MTA were in conflict and that the DMA as a specific statute controls. They also argued that the severed interest was subject to multiple title transactions during the 40-year look-back period, and the title transactions in question that they raised were basically consisted of 2 probate filings in Belmont County. Now remember, the land is also located in Monroe County though. So first, pursuant to the West v. Bode case, the Supreme Court of Ohio determined that the DMA and MTA are not in conflict. And the court noted that the DMA can be used to abandon interest while the MTA can be used to extinguish your interest. Now, with regards to the appellate court in this case, it noted that the MTA is meant to facilitate and simplify land title transactions by permitting a person to rely on the record chain of title. So here the probate filings were insufficient to preserve the severed interests because they occurred in Belmont County and not in Monroe County where the property was located. So, with that said, if an ancillary estate was filed in the county where the property is actually located, being Monroe County, then it could potentially preserve the severed interest under the MTA. So the key distinction here was that the estate was basically filed in Belmont County in lieu of Monroe County, where the property was actually located. The next case deals with Ohio Revised Code section 531.49A. So here in this case, in 1926, James and Rose Logan conveyed the surface to 139 acres in Guernsey County, accepting and reserving therefrom all the coal, gas, and oil with the right of said parties, their heirs and assigns at any time to drill and operate for oil and gas and to mine all coal. So in 1941, James, who was a widower, transferred the mineral rights in a deed specifically referencing the 1926 transaction to C.L. Ogle, whose heirs are the Ericksons in this case. So between 1926 and 1975, the surface was transferred 5 times in recorded instruments, with each reciting the same accepting and reserving language from the 1926 deed, but omitting the word said before the term first parties in 4 of the instruments. So the deed where the Morrisons acquired the surface also included the same accepting and reserving language, but also omitted the word said. So when the Morrisons subsequently assigned the surface to themselves with rights of survivorship and later to the respective trusts, the same accepting and reserving language was used. So in 2017, the Ericks filed an action to quiet title and for a declaratory judgment that they own the mineral rights. And the Morrisons argued that the severed interest had been extinguished under the MTA or abandoned under the DMA. So the trial court granted the Ericksons' motion for summary judgment, declaring that they own the mineral rights. On appeal, the 5th Appellate District reversed, explaining that the reservation does not state by whom the interest was originally reserved, nor to whom the interest was granted. And the court also said that the repetition of the reservation does not endow it with the missing information, nor does it transform the reservation from general to specific. So the Supreme Court of Ohio actually accepted the Ericksons' appeal to review the following proposition of law. The Marketable Title Act does not require that a reservation set forth the name of the person holding the interest in order to be specific and preserve the interest. So the Ericksons claim that neither the MTA nor case law requires a reservation to include the name of the owner of a mineral interest in order for the interest to be preserved. So in the absence of a specific name in the reservation, they contended that a title search would reveal the owner of the reservation by a simple review of the chain of title, reading the reservation deed, and searching that reservation forward in time. So the owner of the reservation can be determined through the chain of title, and therefore the reservation is a specific reference. So the Morrisons, though, relied on Blackstone and argued that when the reference to an interest created prior to the root of title does not provide the relevant page and volume number, then the reference is sufficient to preserve the interest only if it includes both the type of interest created and the name of its owner. So here in this case, each of the title transactions in the Morrisons' chains of title recite that the conveyance is subject to a specific reservation of the mineral rights. The transfer of the surface rights does not contain vague boilerplate language accepting any reservations that may or may not exist. Rather, the Morrisons' root of title and subsequent conveyances are made subject to a specific identifiable reservation of mineral rights recited throughout their chain of title using the same language as the recorded title transaction that created it. So here the court found in favor of the heirs of the parties that reserved the severed mineral interest, basically noting that subsequent instruments in the chain of title basically included a verbatim statement of the reservation language from that initial deed that created the interest. And so since it basically contained a verbatim restatement of that interest, It did not need to include the name of the parties or the volume and page. So this was a big win here for the mineral owners. Now moving forward here, shortly thereafter was the O'Kelly v. Rothenbuehler case out of the 7th District Court of Appeals. So the facts in this case is basically the Erickson decision was issued after oral argument in O'Kelly, but prior to the 7th Appellate District's opinion and judgment entry. So after Erickson was issued, O'Kelly filed a notice of pending relevant appeal to the Ohio Supreme Court but he did not request an additional briefing or oral argument, which he later claimed were essential to the 7th Appellate District's application of Erickson. So the reference at issue in this case is basically states accepting the oil and gas minerals, including coal, underlying the same heretofore conveyed. So the court found that this reference to be general because it lacked any narrow, precise considerations, limited details, or particulars as described in Blackstone. So the reference here is not a verbatim restatement of the original severance language. The original severance deed acceptance reserves oil, gas, and minerals, including coal of whatsoever kinds. Additionally, the original severance language accepts and reserves the full right to develop, same, and to operate on said premises therefore with the essential rights and privileges necessary to such development and operation, including among other things the right to locate and drill thereon and therein oil wells and gas wells to lay pipes to and from said wells. So the reference at issue here omits that language from the severance deed, which serves to describe in detail the rights of the reserving party with respect to the mineral interest. So overall, the court did not find that a repetition must be verbatim or must include development language in order to be specific. The court merely found that the reference in this case would have been more detailed if it contained the verbatim language of all the oil and gas and the development language. So since the reservation language here was not specifically restated in the root of title, it just wasn't detailed enough to basically save that interest from being extinguished. So here the surface owners prevailed. Okay, the next case is the Pernick v. Dallas case. And so which is also out of the 7th District Court of Appeals. So in a 1925 deed, Jasper Dallas reserved the oil and gas rights to the property. In 2018, George Pernick and others as surface owners filed a complaint to quiet title to the oil and gas rights. So Joanne Dallas, one of Jasper's heirs, argued that the surface owner's leasing of the oil and gas within the 40-year look-back period preserved her interest under the MTA. In this action, Dallas actually represented herself, and she argued that the surface owner's leasing of the oil and gas rights within the 40-year period immediately following the root of title preserved her severed interest under the MTA, and also that the 1962 deed was not the proper root of title because it did not expressly purport to convey the surface owner's interest. So the trial court found that the MTA extinguished the severed interest, and the 7th District Court of Appeals affirmed. So addressing Dallas's first claim, the 7th Appellate District agreed that executing and recording an oil and gas lease is both a title transaction under the DMA and preserves a severed interest under the MTA. Even more, where the severed interest owners enters into an oil and gas lease within the 40 years period immediately following the root of title, said the release will operate to prevent extinguishment under the MTA. However, the distinguishment in this case is where the surface owner enters into an oil and gas lease within the 40-year period, it will not operate to prevent extinguishment under the MTA. The court reasoned that a surface owner cannot convey what they do not own. So here, even though there were oil and gas leases recorded within the 40 years after the root of title, those leases were executed by the surface owners. So the severed mineral interest owner couldn't use those leases to, prevent extinguishment of the same severed interest under the MTA. So here, the surface owners ended up prevailing. Next, in Peppertree Farms v. Thonen is a Supreme Court of Ohio case from 2022. So here in this case, Peppertree Farms was the surface owner and they brought an action claiming that the severed oil and gas royalty interests, and so these were pertaining to royalty interest, created in deeds in 1916 and 1921, did not include words of inheritance, and thus terminated upon the death of the grantor in the deeds. So Peppertree also claimed that the MTA extinguished the severed royalty interest. So both deeds were recorded before Ohio rescinded the common law rule in 1925 that grants had to contain words of inheritance, such as heirs and assigns. So prior to 1925, the term exception and reservation had critical impacts. An exception meant that the grantor was retaining an interest that already existed. So if the grantor owned the land in fee, her exception in a deed was also a fee interest. As a result, words of inheritance were not required. Alternatively, if the language created a new interest for the grantor, it was a reservation requiring words of inheritance in order to not be a life estate for the grantor. Additionally, whether an interest was an exception or reservation depended on the intent of the parties, as evidenced by the deed as a whole in light of the circumstances. So in 1925, Ohio made the difference between exceptions and reservations less critical because use of heirs or assigns are now not necessary to create a fee simple estate, and all grants shall convey the entire interest that the grantor could legally grant unless it appears by the instrument that the grantor intended to convey a lesser estate. So nevertheless here though, the court had to apply the law of the time from 1916 to 1921. And so what ended up happening here is the court ended up making a distinction between accrued versus unaccrued royalties. And so the court pointed out that that there is a recognized difference between royalties that have accrued, which are personal property, and the right to unaccrued royalties, which is real property. Additionally, the right to receive royalty in the future is one of the separately inalienable incidents of ownership of the full mineral interest. Accordingly, unaccrued royalties are the retention of an interest that already exists rather than the creation of a new interest. So here, the court found in favor of mineral interest owners by making that distinction between unaccrued versus accrued royalties. Also, as a side note, in Peppertree 2, the court also addressed whether a handwritten recorded will that neither expressly devised the testator's interest in oil and gas nor contained a residuary clause was a title transaction under the MTA, and the court held that it was not a title transaction. So I just included here real quick just a slide for everyone to kind of keep, and it basically breaks down the analysis you'll do for a severed oil and gas interest. As you can see, you identify the proper root of title. Then you see whether there was a specific or general reference to the previously created interest in that root of title. If it's specifically referenced or identified in a monument of in the chain of title within the 40 years after recording date, then it would be preserved. If it's general, then it would be extinguished unless there was a notice to preserve filed or one of the other limitations to record marketable title in 530-419 exist. Next, we're going to move on just to one quick update here on the DMA. So I included these slides for everyone's reference. So I'm not really going to dive into these too deep here, but with the DMA, all the current litigation has really been surrounded the 2006 Act and essentially whether proper notice has been given to the owners of the severed royalty or oil and gas interest or their heirs. So as you can see in the statute here, basically proper notice can be achieved by sending notice of the surface owner's intent to declare the interest abandoned via certified mail to each holder or each holder's successors or assigns at the last known address of each with their return receipt requested. So the real question is how do you determine what level of due diligence is necessary to determine who those heirs are and what their addresses are, or before you can provide notice the publication. And so here in Beckett v. Rosza, this is a very interesting case, but basically Beckett was left with 110.5 acres in Jefferson County, which he left to his children, Grace and Leroy II, by a will which is probated in Jefferson County. So the records reflect that Grace lived in Urbana, Illinois, while Leroy lived in Manchester, Connecticut. Thereafter, Grace and Leroy conveyed the property and separate deeds reserving the oil and gas. And Grace's deed was notarized in Champaign County, Illinois, which is where Urbana is located. So the surface owner here sought to abandon the severed interest under the DMA, and so their counsel conducted searches of the public records in Jefferson County and conveyances or preservations of the severed interest by the Beckett heirs, and they found none, nor any preserving events or any ancillary estates for the heirs in Jefferson County. So they made no attempt to provide notice by certified mail, so they basically published their intent to abandon in Jefferson County in a newspaper there. So in 2017, the heirs of Grace and Leroy leased their undivided interest to Wolf Run, and actually one sold their interest to Wolf Run. And so Wolf Run said that the heirs, Wolf Run and the heirs actually filed suit against Rosza to quiet title because Rosza failed to satisfy the notice requirements of the DMA. And the trial court found in favor of Rosza, noting that although the record shows out-of-state addresses for their heirs, enough time had passed without preserving activities by the heirs such that the Rosza was deemed to have fulfilled her duties under the under the DMA. The seventh appellate jurisdiction actually reversed and entered summary judgment for Beckett. And so the court basically noted that a surface owner's failure to satisfy the due diligence requirements of the DMA is dispositive as to whether the abandonment was effective. So the court cited Garrity, where the Ohio Supreme Court held that there was no bright line test for what constitutes reasonable diligence when attempting to locate heirs. Instead, the court must first determine on a case-by-case basis, basically of reasonableness and common sense. So if independent knowledge or other information discovered leads the surface owner to go out of state or out of county, reasonable diligence requires such action. So here, since basically there was evidence in the Jefferson County probate records that established Leroy lived in Connecticut and Grace lived in Illinois, the search should have been extended outside of the county to those areas to locate the heirs. So here the court found in favor of the several interest owners. Okay, now moving on to production in paying quantities in Ohio. So just as a quick brief rundown here, a paying quantity is a quantity of oil or gas sufficient to yield a profit, even small, to the lessee over operating expenses, even though the drilling costs or equipping costs are not received, and even though the undertaking as a whole may result in a loss. The burden here is on the lessor to show that the lessee has forfeited the lease because of failure to produce gas in paying quantities. Unless there was bad faith or selfish personal motive, the lessee's experience, interest, and judgment under the surrounding circumstances are controlling. So with regards to a temporary cessation of production, a mere temporary cessation in production of oil or gas well will not terminate the lease under a habendum clause where the owner of the lease exercises reasonable diligence and good faith in attempting to resume production of the well. So cessation of production is temporary when the cessation is for a short period of time, and there is no case in Ohio where a court deemed a lease forfeited for less than 2 years of non-production. So here's the first case, which is a really interesting case out of the 5th District Court of Appeals. It's from 2021, but basically the Brownes owned 86 acres in Guernsey County, which was subject to a 1975 oil and gas lease. And so the lease's habendum clause had a secondary term for as long thereafter as oil or gas or either of them is produced by the lessee from said land. And so the Mercer No. 1 well was drilled on the property, which Artex operated from 1999 to 2014. And so Artex records showed the well generated gross revenue of more than $100,000 during that time. Consequently, though, the Brownes filed an action claiming that the lease had expired for failure to produce in paying quantities prior to 1999, so before Artex had taken possession. So in 2018, the 5th Appellate District rendered a decision in Browne and applied a 15-year statute of limitations and held that from 1999 to 2014, the Mercer No. 1 well produced in paying quantities, so Browne's claim failed. The Brownes ended up appealing this decision to the Ohio Supreme Court, and the court accepted but only to decide the appropriate statute of limitations, being either 15 or 21 years. Ultimately, the case was remanded back to the Guernsey County Court of Common Pleas to review under a 21-year statute of limitation and to focus on whether the Mercer No. 1 well had produced in paying quantities during the 6 years between 1993 and 1999. So the trial court again found in favor of Artex and held that the Mercer No. 1 well was producing in paying quantities over that 6-year period. The Brownes appealed again, and the 5th District Appellate Court affirmed. So the 5th Appellate District thoroughly reviewed Artex evidence of the Mercer No. 1 well's production during this time period, such as deposition testimony that there was never a time of more than 2 years when the well was not pumped or produced, and when the prior operator owned the well, about a tank of oil was sold each year. They had an affidavit that, based on the review of the ODNR's records, the well was producing from at least 1991 until 1997. There was an affidavit that the Mercer No. 1 well produced oil between 1981 and 1999. There was witness testimony that there was no indication from the condition and appearance of the well equipment that the well had not been producing. There was deposition testimony that the prior operator never received a complaint that the well was not producing. The 5th Appellate District found this evidence to show that the Mercer No. 1 well was producing in paying quantities from 1993 to 1999. And as a result, the burden shifted to the Brownes to prove otherwise. So they offered the following evidence. An ODNR completions report showing a gap in reported production for the Mercer No. 1 well from 81 to 99. They had a chief's order from the ODNR ordering the operator to suspend production for failure to provide their insurance policy. They had a production graph of no oil production from 81 to 96. There were probate documents of one of the owners of that priorly operated the well, where the estate tax return listed the value of the well as nil. There was a Guernsey tax auditor's records for 1997 and 1999, where the prior operator listed only one well was producing at the end of the year, but not providing any production information. Despite all this evidence, the 5th Appellate District was not persuaded and found that the failure to report production is not the same as reporting zero production with the ODNR. Failure to abide by the chief's order does not strip a lessee of its lease rights. And the production graph is simply just another form of the ODNR well completion report. So those were just not dispositive evidence. Additionally, neither set of the owner, the prior operator's estate documents is relevant because they don't align with the relevant time periods in this case. So overall, this case shows that the court is concerned with firsthand evidence related to the wells in question, not what the ODNR well completions report shows or doesn't show, and not with technical infractions of ODNR producer requirements. So even though you may have information on a well summary, that's not necessarily just dispositive of whether a well is actually producing in paying quantities or not. Okay, the next case is Ullman v. Whitacre. So this case here, Whitacre paid a flat monthly payment to one of its affiliates to manage and maintain wells. Whitacre's business records revealed only the flat monthly payment for each of its 350 wells. The flat monthly payment for each of Whitacre's 350 wells appeared to exceed its monthly revenue. As a result, the Ullmans believed that the well on their property was not producing in paying quantities. However, Whitacre argued that the flat monthly payment was spread across all the wells in its portfolio and that the direct operating expenses did not exceed the income gained from the Ullman well. So here the court held that the operating cost of the well matters in a paying quantities analysis, not the cost of the overhead. So Whitacre established that the flat monthly payment encompassed much more than the cost to operate the well. Whitacre had no office equipment, no employees, so the flat monthly payment, which appeared to be for the Ullman well, was in fact a payment to operate their entire business, including overhead. So when Whitacre plugged the well in its portfolio, the same monthly payment was paid, but the payment total was then spread across the remaining wells. There was also a report that broke out costs between direct operating expenses, which included the direct expenses of operating the Ullman well, and indirect operating expenses, which were the administrative and overhead costs. When only the direct costs were factored into the paying quantities analysis, the Ullman's well monthly revenue exceeded direct costs for most months. Additionally, Ullman also shows that business records are not always conclusive in a paying qualities analysis because they may not tell the whole story. Okay, now moving on real quickly here, we've got 2 cases left for the day, and these are both in Pennsylvania. And so the first here is SLT Holdings versus Mitchell Energy, which is out of the Supreme Court of Pennsylvania. And so the facts here are basically there were 2 parcels of land consisting of basically 1,500 acres, and they were subject to identical oil and gas leases. The original lessee transferred its interest to Mitchell Energy, which drilled 1 well on each of the parcels. These wells were producing and paying quantities until 1996. Afterwards, there was no production from these wells, nor any payments under the leases for 16 years. In 2013, Mitchell Energy pumped and sold oil from the wells. As a result, the lessor, being SLT Holdings, brought suit seeking a judgment that the leases were abandoned. SLT sought a declaratory judgment that Mitchell had no rights to either tract of land, and as a result, Mitchell's failure to maintain its drilling commitment and/or remit delay rental payments resulted in abandonment. And so the issue is really were the leases abandoned for lack of production and paying quantities. And so the trial court here found that Mitchell abandoned the leases by relying on Jacobs v. CNG Transmission Corp., which is another key case. So this decision was affirmed by the Superior Court. The Pennsylvania Supreme Court here found that the lower courts skipped an important step, namely the contractual remedies provided in the leases. So the court focused on paragraph 12 of the lease, which centers on curing a default. And so since there was a built-in contractual remedy in the leases, the court found that this should have been addressed before moving on to the issue of abandonment. So ultimately, the court found that the remedy provided by paragraph 12 was the lessor's sole remedy. The court explained that abandonment is an equitable doctrine and that equity is available only if there's no adequate remedy at law. So the court further observed that absent from the analysis of the trial court or the Supreme Court is an inquiry as to whether SLT determined their adequate remedy under a breach of contract action. And so basically this case was remanded or sent back down to the trial court for further proceedings. So since there was a contractual provision in here with being paragraph 12, where the lessee had to be provided notice of any breach, and the fact that the owners of the tract of land did not comply with that, the court wouldn't even get to the paying and production qualities analysis and essentially just remanded for further proceedings here. And then finally, our last case to finish up for the day is the Walters v. Mcllvee, which is out of the Superior Court of Pennsylvania. And this is a really interesting case, but the Walters basically had land which they sold to the Mcllvees in 2003, and the land consisted of 220 acres. In an unrecorded agreement between the parties, the Walters accepted and reserved all oil, gas, and mineral rights. However, though, the recorded deed did not include any exception or reservation of the oil, gas, and mineral rights due to a scrivener's error. So they had this separate agreement, which basically said that that the Mcllvees would not be getting the oil, gas, and mineral rights. However, they failed to encapsulate that in the actual deed conveyed to the Mcllvees. So the Mcllvees later conveyed 130 of the 220 acres to the Howells. In their unrecorded agreement between the parties, there was a handwritten note which stated that if all mineral rights are excluded, buyer has the option to declare the contract null and void or choose to purchase as is. There was also a second handwritten note that stated no mineral rights included in the purchase. So the recorded deed did not accept or reserve the oil, gas, and mineral rights. As a result, the Howells had assumed that the oil and gas rights did transfer. So the Mcllvees ended up entering into an oil and gas lease with Chesapeake, and then the Walters ended up filing suit seeking reformation of that 2003 deed where they had failed to include the oil and gas and mineral rights reservation, and only had that separate note being the unrecorded agreement. So the issue would be, can oil and gas rights be severed by an unrecorded instrument in your chain of title? and the court found that the Howells were not bona fide purchasers. So although the handwritten note only discussed mineral rights, which typically does not include oil and gas rights in Pennsylvania under the Dunham rule, unless there is clear and convincing evidence otherwise, the court exclusively relied upon the fact that oil and gas development was prevalent in the county where the land is located and that there was little or no coal development. As a result, the court found that the Walters owned oil and gas rights. Again, a very, very interesting case here where the Walters ended up prevailing despite not having that exception or reservation language in their deed, just basically due to the fact that you know, it's a very prevalent area for oil and gas, and the fact is the court ultimately wanted to rule in their favor. So that pretty much wraps up our presentation for today. I know we tried to cover a lot of information across all 3 states. So if you do have any follow-up questions, you know, please feel free to send me an email, and I'd be happy to address any questions you have, or if you want to set up a phone call, that works as well. But again, I really appreciate everyone tuning in for this Appalachia app update. Have a great rest of your day.